Introduction to Environmental Law, Module 6, Provincial and Municipal Environmental Law. By the 1980s, environmental issues were front and center for many Canadians, and Nova Scotians were no exception. In an effort to address these rising environmental concerns, by 1993, the provincial government had enacted a complex patchwork of 16 statutes and 44 sets of regulations administered by the Department of the Environment. For example, of the 16 statutes included a Water Act, an Environmental Protection Act, and an Environmental Assessment Act. Among the 44 regulations were air quality regulations, PCB management regulations, and pesticide regulations. The Nova Scotia Environment Act, which came into force in 1995, attempted to balance non-regulatory and regulatory approaches. The Act placed a strong emphasis on such things as cooperation, communication, education, incentives, and partnerships. The Nova Scotia Environment Act not only consolidated legislation, in many ways it was and remains innovative and progressive. It was one of the first Environment Acts in North America to define such important sustainable development concepts as the precautionary principle, stewardship, pollution prevention, and ecological value. As mentioned previously, the precautionary principle stands for the notion that absolute scientific certainty is not required to take action to stop contamination from occurring. Stewardship recognizes the responsibility of a producer to take ownership of a product from the point of manufacturing to the point of final disposal. Pollution prevention means taking action to prevent pollution before it happens, instead of simply cleaning it up after the fact. Ecological value means maintaining and restoring ecological processes and biological diversity. The Act provides the Minister of the Environment with extensive authority to use tools such as economic instruments to achieve environmental quality objectives. Some examples of economic instruments are user charges, charges imposed on users of products or services that have an adverse effect on the environment, and tax incentives. Projects or activities that do not have a significant adverse effect on the environment can receive tax exemptions, deductions, or credits, while those who do have a significant effect may incur extra costs. The Nova Scotia Environment Act also has specific provisions to encourage public participation in many aspects of environmental assessment and regulatory reviews. The Nova Scotia Environment Act, passed in 1995, has been subject to general review twice. The latest amendments came into force on October 1st, 2012. The most substantive change in the revised Act is to provide more flexibility for the Department to protect the environment. Originally, the Act used a one-size-fits-all approach, whereby the Department issued approvals to regulate over 100 activities. The process for approvals was the same regardless of the risk imposed to the environment. Changes to the Act allows the Department officials to introduce rules and enforce standards for specific activities, use the best approach to protect the environment rather than take a one-size-fits-all, allows staff to spend more time in the field and less time processing applications. The 2012 Act clarifies what a standard is and that it can be used to govern an activity. In the Act, the definition reads, a standard, policy, code, guideline, protocol, or other rule in relation to a designated activity that, by reason of its establishment or adoption, by regulation or as a condition of an approval or certification of qualification becomes a mandatory requirement for participation in that designated activity. As stated, a standard must be adopted by regulation or attached as terms and conditions of an approval for a designated activity in order to be binding. However, a standard under the Act is a ministerial regulation, meaning it needs to be approved and signed by the minister. By definition, a notice to the minister provides information that an activity designated in the regulations as requiring a notification is about to be commenced or is to continue beyond the period of time prescribed by the regulations. A notification is a one-way transaction between a client and the minister. The client submits the notification and receives nothing back from the department. There is no authorization, but the client does not have to wait for approval to continue. The Act in 2012 allows for the designation of class approvals, which permits the department to distinguish between streamlined and full approvals under the Act. They require the definition of the classes to be described in a regulation. The 20 headings on this slide, which relate to the sections of the Nova Scotia Environment Act, indicate the breadth of the Act and the way in which it seeks to integrate and capture all of the legal elements relating to overseeing the environment on our behalf. In broad approach, it deals with the minister and the department being able to acquire the information necessary to work effectively in this field. It deals with specific occurrences and activities that have environmental impact, such as release of substances, dangerous goods, contaminated sites, waste resource issues. And it deals with what powers the officers and administrators have to ensure compliance with the Act, including inspections and investigations, orders, appeals, civil remedies, etc. In any legislation, one of its most important parts are the definitions. For terms which we may regard as common knowledge may acquire or be imbued with specific meaning in a particular piece of legislation. In the Nova Scotia Environment Act, key terms include a definition of adverse effect, which is as an effect that impairs or damages the environment, including an adverse effect respecting the health of humans. Contaminant is a substance that causes or may cause an adverse effect. And approvals allow activities that would otherwise violate provisions of the legislation. They ensure an activity is regulated and monitored. Approvals may be issued subject to conditions, as previously noted, and how approvals are issued is described in the Approvals Procedure Regulations. There are over 100 designated activities in Nova Scotia that require an approval. Examples include constructing a wharf or dam, which may also require federal approvals from the Department of Fisheries and Oceans or Transport Canada, approvals relating to the use of water in excess of 23,000 liters from a watercourse per day, application of pesticides to a watercourse or by an aircraft. It is an offense to release a substance into the environment that may cause a significant adverse effect or exceed a level authorized by an approval. If you release, own, or are affected by the substance or become aware that a release has occurred, you must report to the department and remediate any damage. The Act regulates the storage and use of many dangerous goods and pesticides, including asbestos waste, PCBs, petroleum management, pesticides, used oil, motive fuel, and fuel oil. The Minister has the power to designate a site as contaminated. To date, no such designations have been made. The Minister has the power to require cleanup of a site by a responsible party, including anyone that caused or contributed to the contamination, any person or persons responsible for the contaminating substance, an owner or occupier of the site, and/or a previous owner. Section 92 of the Act required the Minister to establish a solid waste resource management strategy, and Section 93 committed the province to a 50% solid waste diversion goal for the year 2000. This was one of the success stories of this legislation. The strategy was adopted in October of 1995 and included bottle deposit refund systems, tire returns, used oil returns, and landfill disposal bans, which included many products such as waste paint, beverage containers, corrugated cardboard, newsprint, used tires, compostable organic materials, etc. All water and watercourses within the province are owned by the Crown and administered by the province as per Section 103. A watercourse is the bed and shore of every river, stream, lake, creek, pond, spring, lagoon, or other natural body of water and the water therein, within the jurisdiction of the province, whether it contains water or not, and all groundwater. Section 105 requires the Minister to develop a water resource management strategy for the province. A drinking water strategy was issued in October of 2002. Nova Scotia uses a multi-barrier water management system comprised of 3 main lines of defense. Keeping water clean involves various programs to prevent contaminants from entering drinking water sources. The next line of defense, making it safe, involves various steps to remove natural or man-made impurities. And the final step is proving it safe, involving the development of stronger monitoring programs and taking swift corrective action when deficiencies are identified. Section 111 requires the Minister to establish ambient air quality standards, establish performance standards for air quality testing and monitoring, and maintain inventories and establish reporting requirements for emission of air contaminants. Open burning is prohibited in Nova Scotia. There are 2 aspects of enforcement of environmental laws: inspections and investigations. An inspection can be carried out at any reasonable time, and inspectors have the powers of a peace officer, must show identification, can seize evidence in plain view, and need permission or a search warrant to enter a dwelling place. Inspections are designed to ensure compliance with the Act and regulations. Should an inspector come to believe that the Act is not being complied with, an investigation will commence. Also, any person can request an investigation under Section 115(1). The department must pursue the request and report to the applicant. It is an offense to intentionally provide false information to an investigator. There are 2 principal ministerial orders: control orders issued by the Minister where there is or will be a violation of the Act and action must be taken to prevent or remedy an adverse effect to the environment, and stop orders issued by the Minister where an irreparable adverse effect is anticipated. The second group of orders are administrative orders issued by officers of the department. Litter orders require the cleanup of litter. Emergency orders are issued in relation to environmental emergencies, usually by an administrator, but must be confirmed by the Minister within 72 hours. Finally, the Minister can issue a temporary approval in advance of a full consideration of an application. Where an individual fails to comply with an order, the minister may carry out the order and recover all reasonable costs incurred. In such cases, an order to pay is then filed as a judgment in court against the real property of the person. Orders exist as a superlien because they take precedence ahead of all other claims. Decisions of the minister, except a decision on an environmental assessment, can be appealed to the Supreme Court of Nova Scotia. As stated in the Act, a decision of the Supreme Court is final. In order to further clarify the significance of Nova Scotians' relationships between the environment and the economy, the government passed the Environmental Goals and Sustainable Prosperity Act in 2007. 2012 marked the 5th anniversary of EGSPA, as it is commonly called, as an experiment in improving governmental performance in promoting sustainable prosperity through the process of setting legislative goals and enhancing accountability. The Municipal Government Act sets out generally what powers are available to all municipalities other than the Halifax Regional Municipality and Cape Breton Regional Municipality, each of which have their own specific legislation. Municipal governments must adhere to the limits of powers as described in these acts. Having said that, the Supreme Court ruled in the Spraytech case on whether a municipality had exceeded its jurisdiction in prohibiting the application of a pesticide within its boundaries that was approved for use in Canada by the federal government. The court stated that, and I quote, "Determining whether a legislative authority has jurisdiction is not just a technical exercise in reading a statute. Rather, it is an exercise that requires a purposive approach. It involves examining the language of a statutory power within the context of the whole statute and within the external social, economic, and policy context in which it was enacted." In Spraytech, the town of Hudson passed a bylaw that restricted application of pesticides within its boundaries. It acted under statutory powers to pass bylaws to regulate for the peace, order, and good government, health, and welfare of its citizens. When the bylaw was challenged by a pesticide applicator, the Supreme Court refused to follow an earlier decision that had taken a narrower technical approach to interpreting municipal enabling powers. Instead, it had to look at the bigger picture of what municipal governments of community representatives should be entitled to do to protect the environment in which their citizens live. It considered even bigger picture of environmental law, including the idea of precaution, which is emerging as an international law principle. In this light, the authorizing provision must be given a benevolent construction. The court found the bylaw to be a valid exercise of the town's jurisdiction. This was a significant decision because it shaped the role of municipalities going forward to take responsibility for environmental effects within their limits.